Hey, Kevin.
Hello, Rebecca.
Here we are. Guess what we're doing?
Is this a Readathon?
It sure is.
Oh, man.
And we have some stuff to talk about that's happened in the last week. Are you ready to go?
Hit me.
All right. Who was the judge in Karen Read's first trial?
That was Bev Cannoni.
That's correct.
Mm-hmm.
Bev Cannoni has received sort of like a rotation through the court. What happens is she's sort of been the chief judge. I mean, I'm going to use all like lay terms for this.
Okay.
She's sort of been like the chief lead judge in the Norfolk County Superior Court.
Mm-hmm.
And she is going to be rotated sort of out, but that's very, very normal.
Mm-hmm.
That being said, this week it was announced that she has been assigned to oversee all matters around the Karen Read case, including the next trial. So even though she's been taken off another high profile murder case, the Walsh case, they have not taken her off of this one, and she will still be the judge in charge.
So that means like all of her previous rulings stay in place. They don't have to start with scratch with the new judge. And yeah, that makes sense.
The second thing that happened this week was the Commonwealth's highest court heard that appeal made by Karen Read's legal team and the opposition of it from the state about not retrying her because of double jeopardy on the most serious charge she was tried on, second-degree murder, and the least serious charge she was tried on, leaving the scene of a death. They seem to care way less about that latter, by the way.
Right.
And of course, this was based on the fact that several jurors have come forward and said they actually had agreed to acquit Karen Read on those two charges, but were never given the opportunity to say so. So the state's highest court heard that this week, heard that argument, and it was kind of spicy.
Okay, this was an oral argument.
This was an oral argument. Karen Read was there. Her father was there. And she was represented by attorney Weinberg, who's that very well-known Boston appellate attorney and defense attorney.
Yep.
And basically, there was a lot of pushback. The judges asked some hard questions, but her attorneys, their argument is essentially that questions can be designed that would demonstrate what we contend, that this was the end of counts 1 and 3. One justice, Scott Kafker, said the issue is an interpretation of constitutional laws, and he asked Weinberg to cite federal cases. And he cited both the Mississippi and Arkansas state cases, but did not deliver a federal precedent. Of course, this is a state matter, so there's a question there.
Even though they're not direct precedents, that a lot of times appellate judges like to make reference to other cases so that they can, I'm going to say copy their reasoning, but these are arguments that have held water. Right?
That's right. And then the Commonwealth had brought ADA Schillinger to represent the Commonwealth side, and they basically said the defense demonstrated it wanted a mistrial in all three of these counts by asking for the Tui Rodriguez rule, and that the defense was very quick to call sidebars in the trial. So their claim that within that 30-second period or whatever, they didn't have a chance to ask for clarification or ask the judge to ask the question isn't true, because they demonstrated how quickly they were able to do that in the trial.
So they're not necessarily arguing the law. They're arguing that the defense was okay with it, and now they're like changing their mind because they know what was behind door number 2.
Exactly.
Okay.
Exactly. And basically they're saying the known case law doesn't apply here. So that's where the the heart of their argument. So that also happened this week. I am doubtful that this court is going to throw out those two charges.
Just based on the way they've been reacting.
Yeah, based on the way they've been reacting. Yeah. But I am also somewhat doubtful that the second-degree murder charge is going to be part of the next trial, if there is a next trial.
Yeah. I mean, that's the thing that I had heard from other people in law enforcement, that they thought that was an overcharge. That was a big reach to say that was a premeditated act of murder, to ram, to put it in reverse and run him over, as is their theory of the case.
Right.
So, that seemed to be something that the jurors were kind of hung up on. So, yeah, I mean, I think that it would be smart if you're the prosecution to pare it down.
Speaking of the next trial, something else that happened this week, the Commonwealth and the defense filed a joint motion to delay trial number 2.
So they agree on something.
Apparently they do, because of preparation reasons, etc., until at least April. Again, I just want to say I have been soft peddling this idea that trial number 2 may never happen, and this does not point to that.
Yeah.
But, clearly the new special DA Brennan, who's in charge of this case, is doing a lot of work, says he needs time to prepare. I have no idea how he's going to make that $75,000 cap. The state has agreed to pay him. I think he's probably already blown by it.
But he's just going to continue on.
They want to push the trial back. Thoughts?
Well, I'm certainly wondering about, with the speed of the appellate court here, is it, are they going to accept the ruling of the appellate court and not push it any further? So that's why I thought, like, oh, no, they're not going to be ready in January. I mean, it's already the beginning of November. I guess, like, if in the first week of December they find out it's still on, that they probably could have proceeded. But it seems like all the parties want to, build a little more time into it. And even though, they've gone over this stuff already, and they have, they're going to be like wash, rinse, repeat on a lot of it, they still want to kind of start over. You don't want to be jumping in the middle of it. So it seems like both parties recognize that there's complexity to the case, that they want to take some time to regroup. And, it doesn't favor one side or the other. Both sides said that they would like that. And in a way, it works out good for both parties. For the defense, it certainly buys them more time for sort of internal review. Like in a football game, sometimes, like, there's a controversial play and the referees, like, miss it. And so what the one team might do is they might call a timeout. And so while that functions as, like, stopping the clock and letting the players do something, they also know it buys time for the referees to take a look at the play.
Right.
So this in that way could kind of work for Karen Read's defense, that the more time before they get to trial, the more time in their minds, somebody on the prosecution will realize the weakness of the case and, potentially do something.
Right. In the meantime, though, the prosecution is signaling that it is going to move forward, and they are filing motions about discovery and things that they want. One of the things that they want, and they filed a motion this week, was to get all of reporter Gretchen Voss's notes and raw tape from interviews that she did with Karen Read for Boston Magazine. Now, you and I have expressed the unsavoriness of that as a journalistic principle.
Yeah.
However, Massachusetts is a state without a journalist shield law.
Okay.
There are limited protections for sources that are on a case-by-case basis in Massachusetts.
Right.
By the way, this is the same in New Hampshire. And my sort of analog for this and the questions I have about it relate to, a situation that happened at my day job, NHPR. We were sued civilly, and the plaintiff asked to see all raw stuff, internal communications, reporter's notes about the story. Work product. And in a surprising and unprecedented move, a judge in New Hampshire said, turn them over to me.
I will review them in camera and make a decision as to whether or not it's relevant and can be used in this trial.
But that stirred up a lot of controversy. Multiple media organizations filed amicus briefs on the equivalent of amicus briefs on behalf of NHPR's right to not do that, as did the ACLU. And, the judge ultimately reviewed everything and ruled in NHPR's favor, and the lawsuit was thrown out. However,
it seemed to rule not on the arguments about press freedom, but looking at the actual documents and realized there was nothing there that would indicate actual malice. Right.
And he actually ruled that way. So there is a middle ground here where Judge Cannoni may ask to see everything. That could happen, or people might intervene, or the court could decide that source protection does extend to Karen Read, and it also could be a Fifth Amendment issue.
Right now, is this the magazine, the Vanity Fair article,
or Boston magazine,
the Boston
article.
one?
Yeah.
So that we believe, we know the publisher is in Boston, and we assume that the reporter is from Massachusetts.
That's right.
That's right. Okay. Well, the thing that often happens in this case, this isn't a Karen Read call. This is a call for the media outlet, and if the reporter is so inclined, they may refuse to comply.
Right. Absolutely.
And, they'd be held in contempt of court. But, I'm not certain. Well, I don't, again, this is a complete fishing expedition.
Could be.
Yeah, I mean, she's printed everything that, not, everything, but I mean, if there's an assumption here that, there's something incriminating that she didn't pull out.
Yeah. Can you imagine that Karen Read told Gretchen Voss, no, I actually did it, but I want you to write that I didn't. I think I didn't.
Yeah.
I mean, that's wild.
Yeah. No, I mean, they're looking for like some inconsistency
They're
that they
looking
can,
for an inconsistency.
they can trip her up with. Yeah.
Or they're looking for something that they can then mine to go down another path. Like if she mentions somebody else, like they can then question that person, etc.
Yeah, because they know that Karen Read will not, testify on the stand, but they can use all of these different interviews on television and, on the page to act as a proxy for her testimony, and then, confront her that way.
Right. I just want to talk about that not testifying thing for a second. Mm-hmm. Of the many very toxic sock puppet troll anti-Karen Read accounts, the thing that keeps coming out over and over and over again is, why will she give all these media outlets interviews but refuse to testify in trial? She's a coward. Mm-hmm. It is exceedingly common for murder defendants to not testify in their own defense.
Oh, yeah.
Yeah, exceedingly common. And a lawyer would advise any defendant not to do so, correct?
Yeah, it's very rare.
Yeah. So I just want to say, when people call someone a coward for not testifying in their own defense, it's just not true. It's a tried and true legal strategy, and it actually is for the protection of the client. So it has nothing to do with cowardice.
It's her constitutional right.
It's her constitutional right. It has nothing to do with cowardice. Mm-hmm. All right. So speaking of...
Because I would say that if she did, she'd be acting foolhardy.
Correct.
Yeah.
So speaking of request for discovery, the defense has filed a motion requesting all of Norfolk County DA Michael Morrissey's communications related to the Karen Read case from his personal devices and personal email address.
They want the DA's personal communications.
This is related...
in a criminal trial. Now, remind us why there might be something here.
Right. This is related to the so-called Betterow letter. Betterow is Aidan Carney, a.k.a. Turtle Boy's attorney. Mm-hmm. And they have discovered somehow an email from Michael Morrissey's personal email account to other judges and other courts in the state relating to the case, relating to Aidan Carney's case and Karen Read's case. Mm-hmm. So basically what the defense is saying is there's proven extrajudicial communication. You might remember that Michael Morrissey's email also accused a so-called whistleblower inside the office, inside the Norfolk County Court's office, of providing Carney with information inappropriately, which was just public information that maybe they applied early. Mm-hmm. But it actually was about that, and it showed that Morrissey is willing to use his personal accounts to do extrajudicial communication. So they have filed a request to see all of that communication from his personal devices, his phone, so texts and so forth, and his email. Can
you remind us sort of what was in the email and why it was relevant? Because one of the things I remember is the misspelling of Karen Read's name.
That's right.
Which seemed intentional, because if you do a find, the control F as the ability to, give us all documentation relating to, it would be one way for it to, if you wanted to do it on purpose, it would be a way to avoid discovery.
Absolutely.
I think, or they may argue something like, well, there's nothing in here that would be exculpatory for the defense, so in our judgment, we don't have to turn it over. However, this does indicate, the machinations of the prosecution that is part of like both of these cases of these allegations here.
Right.
So what was in that?
What was in the email specifically was that Chris Albert had come to court for a hearing where he was trying to get basically a restraining order, the equivalent of a restraining order of protection against Aidan Carney. His order was denied. His request was denied by the judge. And somebody inside the courthouse told Aidan Carney that Chris had been there and sent him the petition that Chris had filed. Now, keep in mind, within a matter of days, this would have been public record, right? So it was a public document. Actually, already was a public document, just maybe hadn't been released yet or made available yet. Michael Morrissey believed he knew who inside the court had sent that to Aidan Carney, and he actually accused somebody by name in this email, and then he also...
This is a court worker. Which is different from an employee of the district attorney's office.
That's right.
So he was reaching out trying to...
It's a civil servant.
Yeah, you're trying to influence the courts or somebody, a court administrator to take action against the person he accuses.
That's right. Retaliation action.
Okay.
So that's what the email was about, but he also referenced the Karen Read case in that email and misspelled Karen Read's name.
Right, and this is from his official email address that would be subject to public
Nope, it was from his
scrutiny and right to know laws.
personal email address.
His personal email address.
Which is quite telling.
Yes. I remember Hillary Clinton got a lot of flack for that.
Sure did.
To this day. They try to avoid, his emails. Okay.
All right. So whether or not that happens, obviously Bev Canoni is going to be in charge of all of this. It remains to be seen, but that was an interesting filing.
Right.
Okay. This is a good one that I want to fill you in on finally. So the prosecution has announced some of the new experts they're bringing in.
Okay.
And they're bringing in a new expert, they say, to look at the data in Karen Read's car. He's somebody that basically reached out to them from Twitter.
Okay.
And his name is Shannon Burgess. He lives in Texas. And he was recommended by their previous expert, Jessica Hyde. But I believe he also had been tweeting about the case and was sort of like recommended through that. From what I saw on Twitter, but it could have just been a recommendation from Jessica Hyde. Who knows? All right. So he basically filed a preliminary report about what he was going to do that was part of the prosecution's sort of assertion that they needed, that they were going to bring in new experts, and also part of their assertion that they needed more time to trial. One of them was to prepare for this and to prepare this witness. The issue is, as Olivia Lambo, Twitter Susan Simpson, Olivia Lambo, TikTok Susan Simpson, immediately pointed out, this guy seems like a real dope. In his report, he mistook megabytes for megabits and other such kind of mistakes. Okay. He said basically that, he said something about the chips that just wasn't factually true.
Right.
And they were also saying that her car would be shipped to Texas for examination at Karen Read's expense. Okay.
The prosecution wants that.
Yes.
Yeah, okay.
So there's a new filing from the defense, a motion pushing back on this state's expert
to test
the Lexus. So the motion's very interesting. It basically says there's a affidavit from another expert who's named Matt DeSagra under oath. He basically says, I'm a licensed professional engineer. The following facts and information are based on my knowledge. I have reviewed the Commonwealth's Notice of Scheduling, Reassembly, and Testing of Defendants' Lexus telematics system and proposed protocol prepared by Shannon Burgess. Certain statements, this is a quote from the motion and the affidavit, certain statements set forth in Mr. Burgess's proposed protocol, which form the basis of his opinions, are factually inaccurate. Examples. Mr. Burgess misstates the memory storage capacity of the chips in question by failing to account for the differences between a megabyte, megabit, gigabyte, and gigabit. Conversion between and among these units is a fundamental digital forensics concept, which necessarily impacts the acquisition protocols and analyses thereof. He also, this expert says, obtained and reviewed the manufacturing specs of the chips in this telematic system. And Mr. Burgess misstates the memory storage capacity of the chips that were removed from Ms. Read's Lexus infotainment system as follows. And then he has a bunch of examples of the misstatements that are very, technical. You can see expansion S99, JLOX, whatever. So what this counter expert is recommending, and this is what's in the motion, suggesting that Mr. Burgess's proposed protocol be amended. Okay. Step 1, labeled reattempt chip-off, is unnecessary because the full size of the acquisition performed by Mrs. Gaffney already matches the memory storage capacity of the components. However, number 2, defendant's expert shall be permitted to be present during any future testing or data acquisition conducted by the Commonwealth or its experts. So they're saying, you guys hire an expert, we want our expert to be there for the testing.
Okay.
Interesting ask.
Yep, that's a good ask.
And the third thing they're asking is defendant's expert shall be permitted immediately to halt any testing that I deem places the data at issue to prevent the unnecessary destruction of data until such time as the defense can be heard before this court. So basically what they're saying is, please immediately halt any potential testing, because as we know from previous testing, the prosecution claimed that data was destroyed. So until you give us an answer, like put a stay on expert testing by the prosecution. Thoughts?
Knowing Judge Canoni, my guess will be that she will allow both these experts in and then let the defense try to impeach the expert on the stand.
Right. She'll say basically it's up to the jury.
It's up to the jury.
Right.
Right, yeah.
She's always erred on the side of prosecution witnesses and has excluded or signaled exclusion of defense witnesses. That is a pattern, a known pattern in this case. For instance, the prosecution was allowed to have Trooper Paul come testify.
Which didn't work out for them.
It did not work out for them, but I believe if the defense were able to sort of impeach his quote expert testimony, they would have done so in advance of the trial. Guarino is now impeachable. Nicholas Guarino. He's the trooper that looked at data in Karen's car, plus also telephone stuff from Jen McCabe and so forth, and said there was nothing there, essentially. And of course, the FBI reports showed there's a lot there. So some of their witnesses that she allowed in before, or that were allowed in before and not allowed to be countered, have already been impeached because they're either not usable.
Well, that's why they're looking out for a different expert.
Absolutely, they're expert shopping.
Right.
And they want an expert who's going to give them the answers they want.
Yeah. I mean, sometimes you find a good guy from Twitter, and sometimes you don't. But yeah, I mean, I think that as I'm reading this filing, they're arguing that the guy's information is wrong, as opposed to saying this guy is not a suitable expert to give expert testimony to a jury.
They're saying he's a dummy.
Yes. I don't, but I think the arguments tend to be focused on the fact that he's wrong about stuff, as opposed to he doesn't have the bona fides. I mean, I can just stand up and say, well, I'm an expert in this, but
They're not saying don't let him come to trial. They're saying don't let him fuck up the car. And we want to be there when he tests because he appears to be a dummy. By the way, he's also a former local and state police officer, this expert.
Oh, okay.
So
all right.
He might be coming at this with a POV.
A POV.
As the young say.
Yeah, okay.
Yeah, so those are my updates for this week. One notable thing that happened at the high court hearing was that Karen Read's father came out and gave a statement afterwards, and he declared, absolutely, my daughter is factually innocent. And he said that publicly outside the court. It was quite a moment. So here's where we are this week in the Readathon, Kevin. Do you have any final thoughts?
No, this just keeps going along. I'm looking forward to seeing in the next couple of weeks how this appellate court rules. I'm kind of reading the tea leaves that's probably not going anywhere. And we'll have to see what happens in the next 4 months if there are more changes to, the game plan here. Yeah. You know what I really want to do? What? I want to read all of Morrissey's emails from his personal account. I so want to read those, don't you? Yeah. I mean, oh, man. I mean, who... because there are rumblings that what this FBI investigation was not strictly about Karen Read and was not specifically about Sandra Birchmore, but the reason all these things keep getting caught up in FBI investigations is because they're up at the top looking at the DA. Correct. Which could or could not be true, and if it is, well then I'm sure the FBI would love to take a look at that stuff too. I just want to throw in one thing I've been thinking about. Yeah. Aidan Carney started on this show, and I told you as well that, with Donald Trump's reelection as president of the United States, he absolutely has the power to essentially fire Josh Levy as the U.S. attorney for the District of Massachusetts. Right. And replace him with somebody more aligned with what he thinks are his political values. Okay. And there was some fear expressed that a replacement U.S. attorney would drop this investigation or not continue or not care. But here's what I've been thinking. Michael Morrissey is a Democrat. I would imagine, and this is just me imagining, that a Trump-aligned attorney might come into the office and see a great opportunity to take down a Democrat. And that's something I think to remember, is that the politics of this are wonky and weird. And Massachusetts is absolutely operated by old school, backroom, smoke-filled room Democrat types. And, a lot of the corruption around them is apparent and obvious. And it isn't because of their party. It's because of who they are. But parties hate parties. So I think that's something to think about. Yeah. And if the FBI operates in the future in the way it has in the past, it's not going to give too much weight to what party or how powerful different people are, and they're just going to push through on this. And I would imagine, I don't imagine that at Mar-a-Lago, this is a topic of discussion at all, and this is on anyone's radar, and say we got to get somebody. It's not a litmus test for who's going to be the next U.S. attorney for the Commonwealth of Massachusetts. I just feel like a lot of this work is being handled sort of at one lower level with people who are still going to be there, and they'll move it along. So
that would be.
But I mean,
great.
who knows? Who knows? There are so many things about the future none of us know.
That's right. It's very different than the future in 2016 when we were like, oh, let's see. We have no idea what's going to happen. We have a better idea now, right?
Right.
But some things do remain unknown.
Right. But like you said, we don't know who will get that post, and we don't know what their inclination is on this investigation, in part because we don't know the scope of this investigation.
That's right.
Right.
And for anybody who's going to at me, yes, U.S. attorneys have a 6-year term. However, that term is at the pleasure of the president. I looked it up. All right, Kevin, that does it for this week's Readathon. As soon as something else happens, or as soon as enough things happen, we will sit down again and chat. Thanks so much for joining me.
Partners in Crime Media.